Good morning, Tubineros. Well, most of us are familiar by now with the Citizens United case of the U.S. Supine Court, reaffirming corporate personhood and therefore said person's right to exercise the prerogatives of personhood, like bribing officials in office or those seeking office. But this is not exactly a breaking new wind for this judicial body. It's based on another of its notoriously odious rulings, Santa Clara County, California versus Southern Pacific Railroad Company of 1886. Here, corporate personhood was rationalized as an extension of the 14th Amendment to the U.S. Constitution, establishing and defining personhood on behalf of newly freed slaves. The judicial enforcer of this interpretation was Associate in Justice of the Supreme Court Stephen J. Field, a Connecticut Yankee noted for his scorn of Reconstruction and social equality, who based his entire judicial career on his horror of the Paris Commune of 1871 and dedicated himself to fighting the rise of communism in the United States, with federal Reconstruction being just an attempt. No doubt standing by as a well-paid friend of the Southern Pacific Railroad while Chief Justice of the California Supreme Court was part of this noble crusade. How did the amendment establishing the rights of liberated slaves become twisted by a reactionary court and its jurists as bought and paid for as by corporate money as the current one into a bulwark of privilege and destruction of democracy? Well, I think the question answered itself, but following the loopy logic involved is essential for understanding the twists and turns of those following in Field's well-greased corporate tracks. Fields began by citing Adam Smith. The property which every man has in his own labor, as it is the original foundation of all other property, so it is the most sacred and inviolable. Well, so far so good, and Smith, Field, and Marx are all reading from the same page, even though this concept per se has no standing under constitutional law. From this natural right, he extracted the natural right to property as the fruit of said labor, which property is protected by the U.S. Constitution's guarantee of the right to the pursuit of happiness. That the acquisition, possession, and enjoyment of property was sacred and inalienable, and matters which human government cannot forbid and which it cannot destroy. Notice this says nothing about the manner of its acquisition. If it was acquired by fraud, misrepresentation, as in credit default swaps and a subprime mortgage swindle, for instance, it still remains an inviolable right regardless. Protecting the victim of such abuse, the one defrauded, is secondary to upholding the acquisition thereof. The creditor must always come before the debtor, the basis of class rule. Thus the banker's right is enforced, his insolvency even subsidized, while the defaulter is thrown into the street for trespass. The Santa Clara decision was a Randian fountainhead of reactionary Gilded Age legislation designed to strike down all progressive social legislation. Its theoretical basis was the liberty to contract, essentially a figment of the judicial mind. By holding the worker as a legal equal to his employer, any attempt at regulating conditions of employment, for instance, inhibited the worker's freedom to contract between him and his employer. Unions performed the same illegal action. And thus we see how the 14th Amendment was used to deny working men the right to organize collectively between themselves, or to vote for social legislation to regulate their employer's behavior on the job. So the belief in the natural law of property, a free contract between master and servant, this term is still used in many states, look it up, became the basis of granting contractees a legally contrived personhood, and of stopping state legislatures from succumbing to the virus of communism sweeping over the Atlantic from the smoldering rubble of Paris, and the equal right under the law of the rich man in his castle and the poor man in his gate to engage each other's services. It was enshrined as the very essence of American liberty. Private chartered corporations didn't seek this personhood status, of course, until the 14th Amendment made being a person worthwhile. A law meant to define and protect the status of natural-born residents who were not immigrants, Indians, or other foreign nationals, not minors, but had just fallen into the lap of the law virtually from above, as instant persons and citizens. This amendment was the basis for a new definition of personhood. In 1870, in New Orleans, the case of Continental Insurance versus New Orleans ruled that only natural persons can be born and naturalized. Since corporations can't be born and naturalized, they can't be citizens. But in Justice Field held that because corporations are aggregations of individuals, this combination forms a collective personhood representing the individuals involved. Then instead of every individual involved in a corporation being legally liable, the corporation must act as the legal figurehead, representative of their persons. So once again was reaffirmed the billionaire CEO's equality before the law with his minimum wage employee with a juridic person to represent the CEO. But if the worker tried to combine, to unionize, to create his own collective personhood, why, that's unacceptable, because the union is not established on property right, but on restriction of the boss's property right. What about the worker's right of property in his own labor, quoting Adam Smith, where we started out down this twisted path? But these workers are not entering into a free contract with each other to work, but, remember, their employer. Hence, again, they have no right to enter into any competing arrangement violating that contract. So that is how the amendment establishing the identity of free men for their protection and the right of free contract became the rationale for the indentured servitude of the living American worker to an abstract person with more real power than God at its genderless disposal. And raising the issue of gender brings us to procreation issues, which I see as a sly attempt to reaffirm fictitious corporate personhood. We already see an open hint of this in the off-the-wall legislation trying to define inviolable personhood and citizenship at conception, as in Mississippi. Coming from that arch-defending legislature of slavery and segregation, this is richly ironic. Maybe Mississippi is trying to make amends for its past by throwing the shielding grasp of the state around its potential future citizens. If every sperm becomes a legally protected person, then it logically follows that everyone over 18 caught whacking off and flushing the issue down the toilet can be charged with violating the right to life and liberty of actual U.S. citizens. And in fact, in the state of Arizona, person is protected even before the act of procreation under some new ridiculous law. So the very tissues of one's body are turned into tools of class war against the born and the living. It surely is no coincidence, no accident, that billionaire corporate activists are standing behind the abortion issue, behind anti-contraception measures as in Mississippi and Arizona, aligned with the Catholic Church, not out of any deep spiritual reverence for the mysteries of the human soul made flesh, but as a new legal device for redefining personhood, citizenship, and thus their own abstract, contrived claims to both. Thus the Catholic Church in the U.S. and the Pope in the Vatican play whore of Babylon to the rich merchants of the West. One sterile entity backs another, while both back in the vulnerable and the defenseless, left in their charge by the wicked stepmother of the law. Uh-oh. Wonder who this is. Hello? Who? Don Corleone. Can you turn that down a little bit, please? What's that? You just want to say, as a good Catholic and an American businessman, you see nothing wrong with corporations and sperms being people too? And their right to make a free contract, because you've always made them offers they can't refuse. Grazie for clearing that up, Godfather. You're the very man the Supreme Court had in mind.